So, good evening everyone. We are now on Article 125 of the Revised Penal Code, arbitrary detention by failing to deliver the detained person to proper judicial authorities. Gisumpayan ako within 12, 18, or 36 hours. Ganiha, balik ko na ako 124. We are not talking about sa 12, 18, 36. Ang atong gistoryahan dito is gidetain nimo ang usa ka tawo without legal grounds. Pwede na siya ma-arbitrary. Now sa Article 125, lain siya. Nga naman, sa Article 125, gidetain na siya nimo with legal grounds. Ha, timan niya, na kay legal grounds sa pag-aresto sa usa ka tawo. But wala nimo siya na filean immediately within or not immediately, gifilean nimo within the prescribed period. Kumingon tag 12, of course, katong gitawag nato nga slight penalties or felonies. Kumingon taog 18, kanang gitawag nito nga correctional or least grave, and kumingon taog 36 muna siya mga grave felonies. So, based on the discussion on book 1, makonsider na nato or ma-determine na nato unsa na mga gingon nato nga grave, least grave, or light penalties, because I already discussed Article 9 and of course Article 26 of the Revised Penal Code. So, let us proceed on the elements kung kanos ang makomit ang Article 125. I want to emphasize again that when we talk about Article 124, we are talking about gi-arrest ang usa ka tawo without legal grounds. But on Article 125, gi-arrest ni police officer with legal grounds. Ha, klaro ta ha, klaro ta. First elements, the offender here is a public officer or employee is vested with authority to effect arrest and detain a person. So karon, to effect arrest and detain a person, so atong i-consider si police officer. Ha? Si police officer or public officer, provided na sad nga he is acted on its official capacity or its perform sa iyang duties and responsibilities. Kung si public officer or si police officer ni perform siya on his private capacity, ayaw ni i-apply si gitawag nato nga arbitrary detention, kay klaro man ang kinsa lang nga makakomit ani. Kinsa nga offender, of course si public officer or employee. Second element, that the offender has detained a person for some legal ground. Klaro ta, for some legal ground. Ha, klaro ta, for some legal ground. Since we are talking about for some legal ground, atong hunaon nga na-arrest na nato. Ha, na-arrest na nato si offender based on unsa man, na ay warrant of arrest or warrantless arrest. Of course, arita sa warrantless arrest. Nga naman, kay kumingon ta nga gidakop nato ang usa ka tawo nga naay warrant of arrest, there is no need for us to file. Nga naman, muhatag lang ta or ato na lang i-return. Ha? I-return na lang nato ang ato ang warrant nga ato nang na serve og nato nadakpan. Dili kay mag-file pa kadiha og charge. Nga naman, kay na naman na siya record dito sa court. Nakuha ha? Kay kining gipasabot sa 125 na arrest na nato siya nga ningon ta nga for some legal ground based on warrantless arrest. Ha? Warrantless arrest ha? Kano sa ganyan nato makita ang mahitabo ang warrantless arrest? Warrantless arrest is provided under Article Rule 113, Section 5 of the Rules of Court ngadto sa criminal procedure. So una, kanang gitawag nato nga in flagrante delicto. Kano sa ganang in flagrante delicto, when in his presence the person committed is actually committing or about to commit or committed a crime. Muna siya ang in flagrante. Then second, gitawag nato hot pursuit operation. Mingon tag hot pursuit operation, mingon sa tanga when the offense has just been committed and mingon ta nga that the person committed a crime and the police officer has a personal knowledge that the person to be arrested has committed a crime. And third, kanang gitawag nato nga mga fugitive from justice or escaping from justice, muna gitawag nato nga part siya sa warrantless arrest. Since part man siya sa warrantless arrest, for example, paliko na to ha, sa paragraph 2 kay we are talking about legal ground. Ha, legal ground. Kumingon kag legal ground, of course nadakop na nimo based on warrantless arrest. Una, in flagrante delicto, nakitaan si mong presensya, na si mong tubangan ni commit siya og krimen. Ha? Usa na siya sa ito ang i-considered nga imong gi-arrest nga legal ground. Of course, nakita man nimo nga ni commit siya within your presence. Therefore, as a police officer or a public officer, na kay legal grounds to arrest a person because he violated. Na siya na-violate nga naman. Na mo siya crime nga na-commit. Klaro man ta. Na crime nga na-commit, therefore ato siyang i-aresto. Pero wala tay warrant, wala tay warrant. We will apply warrantless arrest. Legal gyapon siya. Legal gyapon siya in order for us dili na to ma-violate ang iyang constitutional right as provided under Article 3, Section 2 of the Bill of Rights. Klaro ta. Then kinamay tay legal ground nga ato siyang gi-arrest, of course, mo continue ta on the third element. The second element requires that the offender arrest and detains a person for some legal ground. Requires that the offender arrest and detains a person for some legal ground. Karon iya nang gidetains. Gidetain na niya but for some legal ground. So, going back ta sa ato ang warrantless arrest. Okay naman ta sa in flagrante, kasabot na ta. Now, arita sa hot pursuit operation. When we talk of hot pursuit operation, let us consider the word immediacy of the arrest. Nga naman, it is very important nga mayroon ta nga immediacy of the arrest. Kada sa na ito ma-determine? Ma-determine na ito ang immediacy of the arrest from the time of the commission of the crime to the time of the arrest. Dili pwede mo ingon ka nga na-commit ang crime karong adlaw. Nya gidakop nimo adto pa ning pagka after 3 days. Is there considered or ma-consider mo na itong immediacy of the arrest? The answer is no. Why? Di na nimo ma-consider as immediacy of an arrest or immediacy of the arrest. Nga naman, it is already a violation of the right of the person or constitutional right of the person. Katong 2 days nga imuhang wala nimo budakpan, pwede ka maka-apply ato og warrant of arrest. Di na nimo ma-consider as hot pursuit operation. Timan na ninyo para dili ninyo ma-violate ang constitutional right of the person as enshrined under 1987 Philippine Constitution Article 3, Section 2 of the Bill of Rights. Klaro ta ha? Now, let us proceed to have an illustration. What if a person has been arrested in flagrante delicto in a possession of unlicensed firearm? Possession of unlicensed firearm is punished by special penal law. So, I hope also you can connect on the so-called mala prohibita and mala inse. Ngayon ko na siyang gisigwig balik-balik because it is very important and it's very, pag-inon pa, favorite question on board examination. Nga naman, ito ko mala prohibita, of course, we are talking about on the special penal laws. When we talk of mala inse, we are talking about on crime or felonies provided under the RPC. But not all. Dili tanan nga nasa RPC considered na to as mala inse and dili tanan nga special penal law considered na to as mala prohibita. Ang ato lang timanan is that when we talk of mala inse, it is inherently wrong from nature, and when we talk of mala prohibita, it is prohibited, matawag na to nga there is a law that punishing such act. Dili siya not inherently wrong from nature, it becomes only matawag na to nga wrong, it's because there is a law that punishing such act. Atong i-apply ang nolum criminula po na sinilihid, there is no law when there is no crime punishing such act. So, klaro ta. Now, going back to possession of unlicensed firearm, it is a special penal law. Is the arresting officer required to deliver the accused to the proper judicial authorities? Does Article 125 apply even to violation of special penal law? The answer is yes. So, yes, because the law says order equivalent. 12 hours for the crimes punishable by light penalties or their equivalent. That means all their equivalent refers to their equivalent even in cases of committed or crime with the offender or violation of special penal law. Therefore, even if the crime committed or the crime for which the offender is being arrested is based on violation of special penal laws, the arresting police officer has the obligation to deliver the person arrested to proper judicial authorities in consonance with Article 125 of the Revised Penal Code. So, bisan pag imuhang na-commit diha is violation of the RPC, violation of the special penal laws, kinahanglan nga imuhang i-follow, kinahanglan nga imuhang na siyang filean. Filean na nimo siya og kaso, mag-file ka og charge against that person. Otherwise, maheld ka og arbitrary detention. One question nga para inyohang mabantayan kung kanus maingon ta nga nanay proper filing or proper delivery of the charge against that person. Kaya moingon ta nga ay nasa fiscal na submit sa fiskalya ang katong mga papel. Is that, say for example, complaint nga imuhang nasabit nga to sa fiscal is considered already as a proper delivery? Wala na delay on delivery of the person to proper judicial authorities? The answer is no. Why? Because it is very clear, based on Article 125, niingon siya nga judicial authorities. The word is judicial authorities, meaning adto ta sa court itself. Ha? Adto ta sa court itself, mo consider nato nga kanaang nanay proper judicial authorities, meaning ang filing of information mo unay makapastop sa running of the prescriptive period on 12/18/36. Nga naman, fiscal is executive function po na siya diha ang prosecutor. Si prosecutor is under siya sa Secretary of Justice. Executive function na siya. Ha? Executive function. Therefore, kung ang imuang gi-file nga kaso is naa pa na sa prosecutor, naa pa na ni fiscal, wala pa na ning matawag nato nga ni-stop ang running of the prescribed period on 12/18/36, but the filing of the information in court that will stop the running of the prescribed period para dili ka maigo og arbitrary detention. Klaro ta? Dili ang pag-file ngadto sa piskalya, but ang pag-file ni prosecutor or paghimo niya og information para ngadto na sa court for proper charge. Now, let us differentiate sa complaint or information. Kung itag complaint, it is an order in writing, subscribed by the offended party, subscribed by the peace officer or law enforcement officer. While when we talk of information, it is an accusation in writing, meaning it is an accusation, there is already an accusation, there is already a proper charge. Kinsa man ni-subscribe? Subscribed by the fiscal or the prosecutor. Therefore, there is already a proper charge since the definition of information is an accusation in writing. Gisubscribe na ni prosecutor, iyahang gisabit nito sa court para ma-consider na nato or mo-stop na ang running of the prescriptive period para dili maigo si law enforcement officer for arbitrary detention as provided under Article 125. Okay, I hope you understand When we talk of judicial authorities, we are not talking about the fiscal, Kasi fiscal, executive yung function. So, kung arita sa court, para mo-consider na to ang judicial function. So, of course, there is already an intervention of the judges. There na participation ng judges, na participation sa MTC, RTC, or Supreme Court as the case may be. Dili ni prosecutor. Kasi again, balikon ako, prosecutor is executive function. So, masabda na ninyo, kung maabot na mo sa inyong criminal procedure, kay sa criminal procedure natay discussion about Article 112 on preliminary investigation nga magkandak o gitawag nato nga of course preliminary investigation si fiscal para iyahang pasa ngadto ni judge for the issuance of warrant of arrest where the judge will conduct preliminary examination para mo issue og warrant of arrest. Si judge judicial function niyang gihimo, si prosecutor is executive function niyang gihimo. Since executive function man niyang gihimo, kung naa kay mga pangutana based on its findings, based on its resolution, ayaw paglargo sa court kung mo-question ka. But you will adto ka proceed sa Secretary of Justice kay executive function man siya. Now let us proceed. I hope you understand basta may tag 125, we are talking about 12/18/36 and legal grounds sa pagdakop. What if the police officers caught X in the actual act of killing Y? So this saw X and fighting and this saw X stab Y to death. Tima niya, nakita. Meaning to say, natay gitawag nga in flagrante delicto, or caught in the act. Therefore, X is liable of homicide. They arrested X and that was Saturday, Sabado, 3 o'clock in the afternoon. Sunod, Sunday, there is no office. The following day, Monday happens to be declared a special non-working holiday. Therefore, the police officers were able to deliver to the proper judicial officer only on Tuesday. Klaro ta, Tuesday na na-file. 8 o'clock in the morning. They were able to file the case in the fiscal's office for the purpose of proceedings Tuesday 8 o'clock in the morning beyond 36 hours which was required by law. Are the police officers liable for arbitrary detention? The answer is no. Nga naman, wala ta mag-ihap og dili mo start og kanting kung mudakpan kay Sabado, Domingo nya napagi-holiday. Nga naman ang timan-an nato is office hours timani mao na kung mapakasala mo ay magpunta ko og Biyernes kay makatugi mo sa balog Domingo. Nya ikahuman holiday pagis Lunes ug Martes patay. Miyerkules na ka mafailan. Dili ka pwede mingon arbitrary. Nga naman office hours ang giistoryahan nato para maihap nato ang 12/18/36. The answer is no, the police officers are not liable for arbitrary detention. The Secretary of the Department of Justice has made a legal opinion that the SID 12-1836 refers to working hours. Timaniha, working hours. This refers to the time when the courts are open in order to receive the cases to be filed against them. This does not include the crime wherein the courts are closed and they did not receive the complaint or information to be filed against the accused. So, mag-ihap lakas 12-1836 nimo kung working hours. Mao nang way labot si Sabado, Domingo ug holiday kay nga naman sirado ang court ana. Ha? Klaro ta sa Article 125 ha. I hope you understand Article 125 kay basin maglibog mo inig mo apply mo sa Article 124. My dear students, di man ni Article 124 wala tay legal grounds. Gidakop nimo siya. Sa Article 125 naa kay legal grounds nga naman i-apply nato ang warrantless arrest as provided under Article 113 Section 5 of the Rules of Court. Wala nimo gi-follow or gi-file nimo within 12, 18, and 36 depending on the gravity of the felony. I hope you understand. And with that, that's the end of my presentation. And let us continue Article 126 of the Revised Penal Code as considered as the third type of arbitrary detention. Thank you and God bless us all.